The Michael Berry Show.
Professor Josh Blackman joins the program again, our legal expert, a.k.a. Mr. Smarty Pants. We have had a busy Supreme Court session with some important rulings as it affects the Trump administration's ability to do their job and hence this country and you. Professor, let's start with the Trump v. Casa Inc. case, or Casa Inc., regarding whether district courts can simply decide in anywhere America, you know what, Trump can't do that. That ended up at the Supreme Court in an expedited fashion. Talk about that case, if you would.
This is probably the most important case from last year. It involved Trump's birthright citizenship order, where Trump said that we will not give any sort of citizenship papers to children of illegal aliens. But the court didn't decide whether that order itself was lawful. Instead, they decided kind of a procedural issue. That is, how can it be challenged in court? Moments after Trump signed the order, judges in Washington and in the Northeast issued these universal injunctions that basically apply to everyone everywhere. So even though Texas hadn't challenged the policy, children of aliens in Texas would still be protected by it. And that's not how things are supposed to work. So we have a 6-3 decision. Justice Barrett wrote the majority, and the court held that, no, you can't issue these injunctions, but we won't talk about whether Trump's order is legal. We'll do that later. That was the upshot.
Leaving President Trump the ability to be the executive, which our Constitution empowers him to be. Fair?
Right, yeah. I mean, you have these district court judges who are truly intruding on the powers of the executive, and they're going beyond the powers of the judicial branch.
Do you recall ever seeing that in the modern era before?
You know, it started in earnest during the end of the Obama administration, ramped up during the first Trump administration, got even more during the Biden administration, and then during the second Trump administration went off the chain. You had more universal injunctions in the first few months of Trump than all of Biden combined. So I think the Supreme Court really had to intervene and tell the judges, chill, you can't do this. This is not how you're supposed to run a system.
Well, my concern throughout all of this is that the Supreme Court should not be as important to our daily lives as it is and continues to be, and that is because they are engaged in legislative and executive actions instead of simply judiciary behavior. And that concerns me because we don't elect a Supreme Court. But in any case, the case of Free Speech Coalition, Inc. versus Paxton, the state of Texas restrictions on porn and age verification. Talk about that, if you would.
This is an important case for Texas and many states. As I'm sure people know, the internet has a lot of pornography, and some of it you have to pay to get. Sites like Pornhub have always required people to register, but they didn't really do much to verify that they were actually adults. So it was unsurprising that children and minors were able to access material. Texas enacted what I think is a pretty common sense law that if you want to provide, pornography online, you have to have age verification. You and I are old enough to remember, Michael, back in the day, if you wanted to go to the video store, they had the little beaded curtain, right? And you'd go there and you'd show your ID to get those other, not that I ever did this, but you'd go there to get your adult videos. If you want to go buy a Playboy magazine, they're usually wrapped in that plastic, and you have to go show your ID to the cashier. Online, there's no cashier, right? There's no video clerk. So the way you verify your age is by uploading a copy of your driver's license. This is how you buy wine, it's how you buy tobacco, and lots of things. But people said, oh, no, this will chill or access to pornography. People will be afraid of sharing their information online. So it goes to the Supreme Court, and the court rules 6-3 that this policy is constitutional and Texas can use age verification, that even though this might burden some adults from accessing their porn, it's a very useful means to protect children from this material.
So I think fair to say falls under constitutional authority because it's narrowly limited with a real purpose, or narrowly tailored with a real purpose, as opposed to an outright ban on pornography, which could be argued is free speech, not conclusive.
Right. Justice Thomas wrote the majority, and he said that, look, this isn't a ban. it's a restriction, and it does make a difference. And there's a long tradition of governments using age verification for accessing adult materials. It goes back forever. It's different because it's online, and there's a risk that people's credit cards might be released, and people's what kind of porn do they like to watch? That's blackmail material. That risk does exist, but I think it was enough to override the Texas enacted law.
Well, and I think what we can take from this is there has long been an American jurisprudential tradition that a law should be as narrowly tailored as possible and for a specific lawful purpose. And in this case, when you can make the argument that it is for the protection of children, that would be relatively consistent with American jurisprudence. The case of Mahmoud versus Taylor, the public school said to have violated the First Amendment religious freedom rights of parents by eliminating an opt-out option for elementary students exposed to LGBTQ plus inclusive storybooks in the curriculum. Make that make sense, please.
This is such a common sense case, Michael. In Montgomery County, Maryland, which is not Texas, they decided that children were not open enough to learning about gays, lesbians, and transgender people. And they need to bring books into the curriculum, even for 5-year-olds in kindergarten, to learn about this. And the hope was this would stimulate discussion and break what they call heteronormativity. If you know what that is, you're normal, right? You're not supposed to know what that is when you're in kindergarten. But this was designed to sort of break this idea of what gays and lesbians and transgender people are. Some of these books talked about children, saying, "I don't feel like a boy, I feel like a girl," and the parents say, "Well, that's okay." So you can imagine that parents objected to their kids having this material. Initially, Montgomery County let kids opt out of this if their parents opted them out, but it turns out almost everyone opted out. And so then they got rid of the opt-out, and the children had to sit through this instruction. So this was a case really about religion, and these were religious parents, as the case suggests. Mahmoud was not a Christian; he was a Muslim parent. But the Mahmoud family didn't want their kids seeing this material, which directly undermines what they teach about religion and morality and gender. Again, the court split 6-3 on this one, and the court said, yes, parents should be able to opt out their kids from this sort of instruction. There was a very vigorous dissent saying that this is harmful for transgender people, and that the Supreme Court shouldn't play school board. But there's a very deeply rooted right of parents to direct how their kids are taught.
Right. One moment. Professor Josh Blackman, a.k.a. Mr. Smarty Pants, is our guest. More Supreme Court cases coming up. Professor, I would love to keep you on for the hour, but there is a lot of donut talk yet to be had. Would you like to contribute? Do you have a favorite donut joint?
I like Shipley's. That's where my kids like to go.
Okay. A Houston tradition. Let's rush through a couple of these. We did have some rare unanimous decisions. One of them, Ames versus Ohio Department of Youth Services, which is referred to as a reverse discrimination case. What's that?
So Ames was an unusual case where you had basically a heterosexual woman who alleged that she was being discriminated against for basically being a heterosexual woman. And the lower courts basically said, oh, well, she can't bring a claim because she's basically a heterosexual woman. And the court reversed that. Anytime there's discrimination, either against someone of majority or minority sexual orientation, that still applies. You don't have to be a member of a majority group. This was a 9-0 decision by Justice Jackson. And I think it was, a high water mark for the court that not all these cases split 6-3. They often have 9-0 results.
It also builds credibility if you don't rule like a crazy person every time. At least someone can say, see, she's not totally crazy. Gun makers' liability, the Mexican government suing Smith & Wesson brands to claim U.S. Liability over gun violence by drug cartels.
Yeah, this is an unusual case, Michael. There's a federal law that prevents people from suing gun manufacturers because their guns are dangerous. The reason why is it? Well, guns are dangerous. That's what they exist for. But Mexico tried to sue Smith & Wesson, saying, oh, well, the problem is they marketed these guns improperly. They tried to appeal to all these gang members and these cartels. They named guns after, drug runners and stuff. And the Supreme Court said, no, you can't do that. There's a federal ban on suing gun manufacturers, and Mexico can't get around this. This is a case where the lower courts allowed the suits to go forward. This could have bankrupted Smith & Wesson, put these gun manufacturers out of business. So, again, the court had some high water marks where they were 9-0, realizing that you can't do this.
Another 9-0 ruling on May 15th, police use of excessive force in the Barnes versus Felix case.
Right. This is one of these issues that sort of pops up over and over again about when you're able to sue police officers for engaging in excessive force. And I think that, again, the court was pretty unanimous here, right? It's generally the police get deference, but sometimes they go a little bit too far. They have to be subject to liability. And I think even we all agree sometimes in your line of work you screw up and people get treated poorly, should get some relief in court.
Another 9-0 decision, regulation of flavored vapes, FDA versus Wages and White Lion Investments.
Right. This isn't really even about vaping. It's more about sort of the process that can go forward before you sort of make these regulatory changes. It's kind of a nerdy decision, but again, not about vaping, but kind of just about the administrative process that you go through.
Why do you think they took that case? Because they don't have to.
Usually it's to settle what's called a split, where the lower courts are divided on an issue. Also, it's an issue of importance where a lot of people in the vape industry were really, wanting to get this issue settled. But when it's a 9-0, especially a 9-0 reversal, that doesn't mean the lower court got it wrong. It just means that the court says, here's the national standard, here's how we're going to do it.
The case of ghost guns, Garland versus Vanderstock, 7-2 ruling.
Yeah, this one sucked. I was one of the lawyers on this case. My colleague Chad Flores, another lawyer in Houston, we litigated this case for several years. For the longest time, people have been able to make their own guns at home. The 80% receiver kits. People have done this for years, and then recently decided, no, you can't. You can't make these guns at home. Even having a block of metal itself is a gun. You can do it through a background check. When the government changes their position on short notice, it's usually a sign something's up. But we lost this one. I think the government, both Biden and then Trump, persuaded the court that these ghost guns are dangerous and we can't have them. So I'm still a little bitter on this one when you lose the case at the Supreme Court.
I can tell.
Not a good feeling.
TikTok versus Garland. Supreme Court unanimously upheld a law that sought to ban the wildly popular app TikTok in the U.S. unless it were sold. That's the New York Times description.
Yeah, this is an unusual case because Congress, bipartisan, voted to ban TikTok. The Supreme Court said this law is constitutional, that it can go into an effect, yet I'm sure people listening have TikTok on their phones right now. Why? Because before Biden left office, he said, I'm not going to enforce this law. And Trump has said, I'm not going to enforce this law. So we have this law in the books. The Supreme Court upheld it, yet TikTok continues. And I guess Trump's trying to work out some big, beautiful deal to sell TikTok because it's owned by the Chinese. But it's one of these weird cases where the court spoke and it didn't really matter. The law still never went into effect.
Which is interesting because they don't have a self-enforcing mechanism. So for everyone who says, well, the Supreme Court ruled this about Trump and they're so upset about it, he is disregarding the ruling. Well, who was the president who said, I've heard your ruling, now enforce it? I'm trying to remember who that was. But
people say it was Jackson, but he never actually said it. It's kind of a myth.
Okay.
But he got the gist right.
United States versus Scrametti, the Tennessee case.
Oh, this is a big one, Michael. So Tennessee, like Texas, enacted laws that banned what they call gender transition medicine for minors. This is puberty blockers, cross-sex hormones, and then even, operations to change genitals. People said that, no, this law is unconstitutional. It's a form of sex discrimination, and that it infringes on the rights of parents to provide this medical treatment to their kids. The court split 6-3 on this one, and the opinion was by Chief Justice Roberts. It was kind of a narrow decision. All Roberts said is this is just a regulation on age, because if you're over the age of 18, you can get this treatment, but if you're under the age 18, you can't. I'm not sure if that's quite right. I mean, it's pretty much about sex, that if you are a boy and you want to get these drugs and you're trying to become a girl, you can't. But if you're a boy trying to stay as a boy, you can get these drugs. It's kind of a weird ruling, and it kind of avoided the underlying issue. I think the basic issue here is that the state can have an interest in saying we don't want minors changing their genders. And we think that this is something that could be harmful to them later on in life. They might decide to detransition. The science is far from settled, and we don't want this. So the court, I think, got the right result, but the reasoning was not as tight as it should have been.
Talk us all the way up to the break. I'm going to give you talk through the music until we cut you off. How has this court been different than you expected it to be?
Well, so far, I think the court had a fairly decent term, and I think more recently they sort of said to the lower courts, you need to stop. The rate at which they're ruling against Trump and basically stopping from doing anything is too much. A lot of these cases will eventually get to the court in a couple of years. We can't have these lower courts issuing universal injunctions. And as for we often talk about the Trump appointees, this was Kavanaugh's best term. I think he did a pretty good job this term. Gorsuch, okay. Barrett, okay. But Kavanaugh, good one.
Good. Professor Josh Blackman, Mr. Smarty Pants, thank you.
The
More
Michael
donut
Berry
talk
Show.
coming up.
Prices this low can't last long, so hurry into Circuit City.